Polymath Enterprises presents The Polymath Slacker's Guide by Josh Alderman. This is the Polymath Slacker's Guide to the Supreme Court healthcare case. People representing the state of Florida argued that the Patient Protection and Affordable Care Act was unconstitutional in the Supreme Court recently. And fortunately, the audio files for that hearing are available for download at www.supremecourt.gov, so I didn't have to go to Washington, D.C. to sit in on the meetings. In fairness, I supported the law from the start, but still, I don't understand how anything can be called a mandate if it's simply a toothless requirement with no liens or liabilities associated for individuals. Clearly, the law was written to limit infringing on the individual as much as possible, with exemptions for both individuals and small businesses. So it appears this mandate is a strong suggestion to individuals with much more of the legal focus on large corporations and health insurance companies. In order to expand availability to health coverage for the 40 to 50 million people who did not have health insurance coverage in 2009, the mandate is necessary language. I must admit I was compelled to start with by the idea that the government would be forcing us to buy something, but then I learned a few of the many ways around this mandate. We're more or less being instructed to buy insurance, and if we don't, we don't, and that's the end of it. But of course, there are people out there promoting anxiety over this that's not often justified. If you are required to pay for minimum coverage, it will be between $13 and $14 a week. And if $13 or $14 a week cuts significantly into your budget, chances are you're exempt from this mandate anyway. One of the assertions made by the states was that the people who do not have health insurance are healthy, or that they are choosing not to get health insurance because they're inherently healthy people. However, that's a myth because there is no immutable class of healthy people that don't require this coverage. These young invincibles, so to speak, can't be excluded from the health insurance market simply because we don't know who's going to break their ankle or have their appendix burst or contract diabetes. Every American will need healthcare services at some point, and it is impossible to know who or when in advance. The food market mentioned in the arguments is a completely different subject. First of all, an individual needing food does not create liability for other actors in the food market. It is true that increased demand drives price increases. However, the type of cost shifting that goes on in healthcare is not present in the food market. Basically, it's not an apples to apples comparison, pardon the pun. Everyone is in the food market. However, they are not restricted in the way they pay for food, the way that they're restricted in the way they can pay for health care services in the health care market. If one were to make a list of every item in their local grocery store and a list of every health insurance plan available in their area, people would be absolutely less restricted from the food market than they would be from the health insurance market. To begin with, this whole fight is about the fact that people who state as their goal dismantling all forms of government lost this debate on a national level in the federal government. So they invested tremendous amounts of money in taking over the state governments. And their arguments are often driven by ideology, which explains their failure to correlate this law to existing case law. Along with broccoli, another recurring theme was the automobile industry. It was asserted that a similar cost shifting takes place in that market due to people's abstaining from the electric car market. This line of thinking, however, gets the automobile market completely backwards. Cars become popular when people want to buy them. If health insurance were available to everyone, I'm sure it would be wildly popular as well. But health insurance companies exclude people who are likely to get sick. And no dealer in the country is required to give you a car, much less sell you one. But if you're taken to a healthcare service provider, they are required to treat you whether you can pay for it or not. I was confused for a minute when I heard one of the attorneys for the state say that he believed that domestic violence is equal to a communicable disease. Just before, one of the justices mentioned something about the standard nut case, and I assumed that this was what they were talking about. I mean, does this mean I have to watch out who I sit next to or shake hands with so I don't contract domestic violence? Just what is the nature of this pathogen that I have to worry about thanks to the standard nut case? Attorney for the plaintiffs. There was a clear and important question throughout the process, however, and it did get answered. And that question is every American in the health insurance market? And according to Justice Kennedy, quote, every American is in the health insurance market because they represent a risk to that market, end quote. And once it is determined that everyone in America represents an actuarial risk to the health insurance market, that, my friends, is interstate commerce. Otherwise, we could be left with the 2009 status quo of pre-existing conditions and no healthcare coverage for 18 to 26-year-olds. Which also highlights the fact that opponents to this plan have offered nothing to replace it with, as though the way it was working fine, and we didn't face a nearly $35 trillion unfunded liability. It seems they want to stop the progress that the country has made and go back to a time with less stability, as though it were somehow possible in life to stop time and declare a winner. The country already has made significant progress. We've acted to ensure the stability of the entire Union. And the best the opposition can do is compare health care to cars and broccoli. Government health care options like Medicaid provide life to people who would otherwise face peril, and life for newborn babies and their mothers all over the country. 60% of Medicaid spending is optional spending done by the states. Medicaid is a program millions of people need and use, and paying for the healthy delivery of children is a major part of Medicaid services. There are also millions of people working within the health care industry, constantly trying to make it better, who support this bill or law. Striking down or repealing the Patient Protection and Affordable Care Act is not like firing a law. It's no simple task, and millions more people would be affected by that than the few million, or if there is that many, that are affected or anxious about this mandate. Lawyers in opposition to the law, it seems, could better spend their time setting up workshops or otherwise educating people on how to get around this mandate rather than trying to attack something that millions of people are going to be benefited from. But the lawyers for the plaintiffs in the case state that the problem is not a failure to purchase health insurance. It's a failure for people who have received services to pay for them. It's circular, I know. They say strengthening the ability of providers to recover their expenses from these patients, these free riders, is the answer to the insurance risk assessment. That practice, however, if implemented, would lead to people making even more poor decisions about their healthcare choices. It comes down to a choice between your life and your freedom, as those who desperately need care choose to forego it rather than burdening themselves with lifelong payments. Fortunately, though, people who disagree with the plaintiffs in this case don't have to convince the plaintiffs that they are wrong. We just need to have a practical discussion with the majority of America, and then the chips will fall where they may. Maybe the most compelling hypothetical in the whole discussion was Alito's burial insurance. He said, and correctly, that we will all need that service at some point, and not everyone will pay for that service, and the government must provide that service anyway. But the difference here is that burial service has a finite cost association that is not present in the healthcare market. Burial services have a set cost, whereas healthcare costs can be virtually unlimited. So it's now up to the Supreme Court justices to deliberate on the testimony and offer their opinions. Based strictly on the questions and the comments of the justices, I think the decision's probably going to be 6-3 in support or upholding the law. Then hopefully we can get on with the additional progress that the coming generation expects from us. This recording is seeking to inform the opinion or character of the region or state at least, in the hopes that our choices and representation going forward will actually reflect the will of the people. This has been the Polymath Slacker's Guide to the Supreme Court Healthcare Case. Thank you.